Yeah, but I just, we could just call and see if we should.
I don't know why this computer has to think so long before it lets me log in.
Yes. This one is.
I just want them all old, but that's fine. I just want to look at it. It's not happening. Thank you. I mean, I've heard it, but
I don't think so. She's just good. That's her. That's it. And she's not, she's really good.
Okay, Ms. Grant, are you going to be our court reporter today?
Yes, I am. Good morning.
Good morning. Let me get my notes. Okay. Before we get started, there's a person on the Zoom, Mystical Studaway, if I've pronounced that correctly. Oh, okay. Just perfect. You're welcome. Just making sure I can account for everybody that's on there. Thank you very much. Okay, Madam Court Reporter, we are going to get started. This is going to be day 2 of a hearing in the matter of the Merchant Law Firm PC versus Fulton County District Attorney's Office, Fulton County, Georgia, and Fonnie Willis in her individual capacity. Case number, I'm sorry, in her official capacity. If I misspoke, I apologize. Case number 24CV001325. I'll note for the record that counsel for the Merchant Law Firm is present and that counsel for the defendants is present. Where we adjourned yesterday was with Mr. Bond, who is the open records and business records custodian for Fulton County. I believe we were not quite concluded with his testimony when we adjourned yesterday. I assume he's outside and ready to return. Are there any preliminary matters we need to take up before we do that?
just wanted to mention for scheduling purposes, I let the court know and I let counsel know that, so we are planning after this to call Ms. Miller from the county attorney's office. And then we wanted to call one of the IT folks. Ms. Monroe let us know this morning that the IT person that they were, so we subpoenaed Mr. Kerrigan, who's the IT director. He was unavailable yesterday, so we agreed to allow someone to fill in for him, Mr. Slayton, and appear by Zoom. We were told today that Mr. Slayton is not available today. So we asked if Mr. Kerrigan then would be available now, or if Mr. Slayton, and we're fine accommodating by Zoom. But IT would be our next one. And then after that would be Mr. DeSantis. And I sent the court, I sent your staff attorney an email to let the court know with Mr. DeSantis, just out of just to try to be expeditious, we were willing to limit all of our questions with regards to Mr. DeSantis to the initial subpoena, September 5th subpoena, the one that there's no issue about service, just about mentioned documents contained with that, so that we could avoid that whole argument about process on that. Thought that might make it easier if we just agree to limit it to those questions. And then the final issue is the county wants to call me. They told me this morning they want to call me as a witness, and I'm willing to waive service of subpoena, make myself available, but I have to leave by 1 o'clock today. So, and I told them that, and it's for a medical procedure that I have at 2 o'clock. So just wanted to let the court know that first out of the way.
Okay.
Thank you.
Any response, Ms. Monroe?
Yeah, so Mr. Slayton, who is serving as acting CIO, that's the CIO or whatever the position, sorry. He was the head of IT in the place of Mr. Kerrigan, who was away at a conference, and he was available yesterday, but he did not make me aware that he had traveling plans. And so when I informed him of today's hearing, that it carried over, and today he told me that he had a flight scheduled from 9 to 2. And so that he would give us a call when he landed. However, I made him aware that we are planning to conclude today's proceedings at 1 p.m. We'll let them know
That was not the discussion that we had yesterday.
that the proceeding would be done at 1 p.m.
No, the discussion was that Ms. Merchant had to leave at 1 p.m. and that no one had an objection to Mr. Merchant taking over to continue the proceeding. Okay.
No, I for some reason heard differently. I thought we were actually gonna be
Hang on
concluding
just
today
one
at
second.
2. Yeah. Once again.
Sure. Sorry about that interruption, Ms. Monroe.
Okay, so once Mr. Slayton lands, I will be able to make contact with him because I've been emailing him since this morning to, let him know what's happening. I'm just waiting to hear back from him. We're also trying to get in contact with Mr. Kerrigan to see if he can now make himself available by way of Zoom so we can take testimony from him today.
Okay.
Once I hear back from these 2 individuals, I can update the court accordingly.
Okay. Thank you. I appreciate that. So just as I said yesterday, I'm not going to reach out and grab issues that I don't have to reach out and grab. And that includes the extent to which the court is going to rule on any of the motions to quash subpoenas that relate to Mr. DeSantis, Ms. Willis, or any other witnesses. I believe where we left the record yesterday was that Ms. Allaby or Ms. Monroe had indicated that Ms. Miller and Mr. Bond would agree to testify despite the preserved concerns about the subpoenas to those 2 individuals. But I didn't necessarily hear agreement regarding IT, although it sounds like the county was making efforts to make him or someone available. And then, of course, I know there's no agreement regarding Mr. DeSantis and Ms. Willis. So we're going to leave those issues where they are because I still stand by, and even with having had the night for reflection, I still stand by that we'll get there when we need to get there, if we need to get there. Okay? So I think with that, we just need Mr. Bond back on the stand. Is that correct? Okay. Ms. Bergdorf, if you'll watch your chair, because that's okay. You're sort of in the walkway there. Come on in, Mr. Bond.
Good morning.
Good morning, sir. Mr. Bergdorf, I'm sorry. Mr. Bond, I was just speaking to Ms. Bergdorf. Just because there has been a whole day since you were here, I'm going to go ahead and swear you in again. Will you raise your right hand, sir?
Yes, ma'am.
Do you swear that the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Go ahead, Ms. Merchant.
Thank you. Good morning, Mr. Bond.
Good morning.
So when did you first hear about our lawsuit?
When it was filed, April, when it was served, when it was properly served.
And how did you hear about it?
It was properly served. I accepted service. After I accepted service, I sent to the county attorney's office to request representation.
And you did that yourself?
I believe so.
And before that, had anybody mentioned it to you?
Mention a lawsuit?
Yes.
No, I don't recall if anyone talked about the lawsuit until it was filed.
Did anyone ask you to perform any searches after the lawsuit was filed?
In preparation for this hearing and in accordance to a subpoena?
After the lawsuit was filed,
Okay.
has anyone asked you to perform any searches in regards to the lawsuit?
The subpoena is a part of the lawsuit that was supposed, and as a response to the subpoena, a search was conducted. So the answer to that question is yes.
Outside of in response to a subpoena, has anyone asked you to do any searches in regards to this lawsuit?
Your Honor, we object as to the extent of any communications protected by attorney-client privilege.
Fair enough. To the extent that your question is broad enough that it would encompass inquiring about attorney-client or work product in advanced litigation, going to sustain the objection. You can rephrase.
Who is your attorney?
My attorney sits right there. She represents the office. So I'm not sure I understand the question. Who's my attorney? In this case, I don't understand the question.
Who is your attorney in regards to this lawsuit? Who represents you?
Right now, as I'm here in the capacity as the business records custodian, right? For the office of the Fulton County District Attorney, sitting to your left, my right, your left, are counsel who represents this office. And I would say they are counsel for me in my capacity here today.
And that you're referring to Ms. Monroe and Mr. Bowman?
I'm referring to the counsel who is sitting to my right, your left.
Who are Mr. Bowman and Ms. Monroe?
Yeah.
Just,
Thanks. So do you also have independent counsel then, I guess is what you would call it, or another attorney?
If you are referring to in the capacity of a non-party, I have legal counsel for the office of the Fulton County District Attorney in my capacity as a non-party, if that's what you're referring to.
I'm just asking who your attorney is.
Okay.
Um,
In this particular matter?
yes.
Okay. And in my capacity as Board of Custodian of Records, I've answered that question. And in my capacity as a non-party, I believe I answered that question as well.
Thank you. Did anyone ask you to perform any searches outside of the subpoena in regards to our lawsuit?
Not specifically to your lawsuit. I do not recall.
Is it not specifically to my lawsuit, or you don't recall?
So let me be very clear. UK got a lawsuit. In my humble opinion, I thought it was frivolous. I took the lawsuit.
Did you judge object non-responsive?
You asked me a question.
It was.
he can answer the questions the way he wants to answer the questions. As long as we're not going to be abusive to one another, he can say what he thinks if he wants to. Your objection is overruled.
Thank you. I just that he, Judge, I just asked that he actually answer the question, and then he can respond however he'd like.
Well, I think he was in the process of answering the question when you objected to his answer as non-responsive. So let's give him a minute to get the words out. Go ahead.
I received your lawsuit. Once I saw your lawsuit and I recognized who it was from, I could immediately thought that this was a frivolous lawsuit and I needed representation. I sent it over to the county attorney's office because I needed representation on that matter. I did not think anything further to this lawsuit because I anticipated that the lawsuit was going to come, this frivolous lawsuit, and I anticipated that you wanted an opportunity to have a hearing. So yes, I anticipated, and to be quite honest, when I received that particular frivolous lawsuit, in my opinion, and sent it over to the county for representation, I did not read it.
Okay, my question was, you answered that you either did not, you said first that you didn't do any searches, and then you said you don't remember. So my question again for the third time is, Did you not do any searches, or is it that you don't remember?
So I'm gonna answer this question again. You gave me a lawsuit, which I thought was frivolous. I'm telling you, I did not read the lawsuit. So if you're asking me a specific search for your lawsuit, I didn't care about your lawsuit. I sent it over to the county for representation because we knew that this was going to be, one, in my opinion, frivolous, and two, that you wanted an evidentiary hearing. And I knew that whatever was coming through the evidentiary hearing that I can address in court. So that's the answer to your question. If you're asked,
So let me jump in here for a minute. Because I absolutely agree that you're entitled to answer the question in any way you want. But now I think Ms. Merchant is right that you're not actually, her question is, did you conduct any searches after the lawsuit? Now I think I understand your answer to be, you didn't think the lawsuit merited action or attention by you, and that's fair. But her question is, did you conduct any searches after the lawsuit? And that's a yes or no question. And then you can explain if you did or didn't, or why not.
the answer is yes, because the subpoena was a part of the lawsuit. And when the subpoena, a part of the lawsuit, was received by me, a search was conducted.
So let's narrow it down to that then. Between April, when you said you got this service of the lawsuit, until you got the subpoena. So excluding the subpoena, just April to when you got the subpoena, did you do any searches?
Your Honor, she said, did I do any searches? I do not understand the question.
You can ask her to clarify.
May you clarify the question?
Did you do any searches in regards to the issues in this lawsuit?
I cannot answer that question. Why? Because I thought your lawsuit was frivolous. And I'm using your terms, Your Honor, so forgive me. It did not merit any work for me because of who you are and what you alleged. So I sent it over to the Fulton County for representation. So I was not familiar with the allegations therein to answer the question specifically that I looked at your lawsuit, read your lawsuit, and did a search in accordance with your lawsuit. I didn't read it.
Okay, I'm gonna ask it again. Between when you received the lawsuit in April, up until the time you got subpoenaed, did you perform, I'm not asking if you thought the lawsuit had merit, I'm asking if you performed any searches. Yes or no?
I cannot recall if it, no, I did not do any searches as it relates to your lawsuit because was not familiar with the contents therein. Did I do some searches? Yes.
So no or yes? You've said both. And I'm just trying to be clear. Did you do any searches in regards to this lawsuit?
So your lawsuit, as I understand it, makes allegations of a wide range of issues, right? Let's just say issues 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. If I answer, I did not do searches for 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 and say, hey, I didn't do anything in response to your lawsuit, right? Then you're going to say, hey, this number 3 was in a lawsuit and I can see that you did searches. And I'm telling you, I don't know what's in the lawsuit. Did I do searches? The answer is yes, I did. Did I do it in response to your lawsuit? The answer is no, because I didn't know what was in the lawsuit. You made a lot of frivolous allegation. So I do not know 1, 2, 3, what was in it. So if you're asking me,
You're the records custodian for the Fulton County District Attorney's Office, correct?
I am.
And so, and you were brought here to testify about all of the records, all matters about open records requests in regards to Fulton County DA, correct? As the custodian, that's your job.
No, I was brought here to talk about relevant information as it relates to this particular hearing. So yes.
And if there's an open records lawsuit filed against the Fulton County District Attorney's Office, that would come under your job description, correct? Something that you would pay attention to.
Along with my counsel, the answer is yes.
And so you received service of this in April. We agree to that, correct?
We do agree with that.
And you received a subpoena in August. We agree to that.
No, we don't agree to that. Let's be very clear.
Well, I think my recollection of your testimony yesterday is that we were in agreement that it was received, but maybe had a disagreement about whether and how it was served. Is that fair?
That's fair.
Okay, thank you.
Let's break it down even further. In the month of April, did you do any searches for any additional documents in regards to the issues in this lawsuit? And just April, Just April.
I do not know how to answer that question because I was not aware in April what the issues to this lawsuits were. So I cannot answer that question.
Can I ask for a piece of clarification, Ms. Merchant?
Yes.
By issues in this lawsuit, do you mean the open records requests that are the subject of the lawsuit?
Yes. And when I asked it that way, it got a,
I understand.
Yeah,
I'm just trying to make sure we're all three
Yes.
having this same conversation.
I am too. And my goal is to get information from you. So if I'm not clear, I want to try and be as clear as possible. What I'm trying to find out is between April, when you got the lawsuit, and when my subpoena, not asking you about to comment on the subpoena, when my subpoena was served in August, during those months, did you do any additional searches about the subject matter? The subject matter being my open records requests, the documents I was seeking. Did you do any searches in that period of time?
No, I don't believe so.
Thank you. Have you spoken with Ms. Willis about the lawsuit?
She knows that a lawsuit was filed and she knows that I had to request representation. To that extent, yes.
So the only conversations you've had with her is about getting representation and the lawsuit actually being filed.
The only conversation I had with her was, we need representation because we have, I accepted service and I need representation. I have told her that I need to be a peer before in court.
Have you ever discussed the documents at issue in this lawsuit with Ms. Willis?
I don't recall. No, I don't believe so.
No, you don't believe you've discussed any of the documents at issue in this with Ms. Willis?
In this, break it down, ask me the specific documents and I can tell you if I did.
Have you discussed the critical mention documents with Ms. Willis?
I don't think I specifically said, I don't think I specifically asked Ms. Willis anything about critical. It's hard to answer that question. What documents are you talking about? Are you talking about emails? Are you talking about the analytical graphs?
Have you discussed any of the documents regarding critical mention, any of them, with Ms. Willis?
Have I talked about critical mention or sought information about that in a meeting? The answer is yes. If I have a document related to critical mention and said, here's a document for critical mention, can we discuss? The answer is no.
In regards to this lawsuit?
You know what I think about this lawsuit, so you're gonna have to be specific. Hold on, I'm sorry.
All I said in
Clarify.
regards to this lawsuit, I hadn't even asked a question yet. I just asked,
Okay.
let me ask the question. In regards to this lawsuit, have you discussed, you asked me to break down the questions individually. So all of these next questions are about this lawsuit. Did you discuss critical mention documents? The production of critical mention documents with Ms. Willis?
The production of critical mention documents with Ms. Willis, and the answer is no.
Did you discuss the existence of critical mention documents with Ms. Willis?
I do not recall the existence of documents. I do recall a conversation in a staff meeting in a group setting. What is critical mention? I do recall that. And I believe that District Attorney Fonnie T. Willis was present.
Outside of the staff meeting conversation, have you had any other conversations with Ms. Willis about critical mention documents?
About critical mention documents, the answer is no.
Have you had outside of that, have you had any conversations with Ms. Willis about the forfeiture documents that were sought in this lawsuit and the open records?
Outside of that, what do you talk? Please clarify.
Outside of the critical mention, I was moving on. I was
Okay.
breaking it down. You'd asked me to go through each
Mhm.
subcategory of document. So
Mhm.
outside of critical mention, we're moving on from that.
Okay.
Forfeiture docs, talking about forfeiture docs. Have you discussed forfeiture documents, the production of forfeiture documents in regards to our open records?
No, the answer is
Or
no.
our lawsuit with Ms. Willis?
The answer is no, because the forfeiture documents, as I stated yesterday, that request was received. I responded to that request. I told you what I did to get that request. I told you that I contacted the clerk of the Board of Commissions. I responded to that. I gave that to you on January 26th, free of charge. There, I did not do anything other with that particular open records request because that was satisfied. So no, I did not talk to the district attorney or anyone else in my staff as it relates to that particular request, because I handled that one personally and responded to your open records request.
Maybe I wasn't clear. Let me rephrase it. In regards to the lawsuit and the open records request, the lawsuit, you did not just answer about the lawsuit. Have you discussed production of forfeiture documents with Ms. Willis?
I answered that question, and I'm going to answer it again. I have never talked to District Attorney Fonnie T. Willis as it relates to the production of your open records request, because your open records request said that you.
Judge, it's non-responsive.
Hang on.
It's non-responsive.
Well, the first part of it was responsive, which was I've never talked to.
But then he qualified never in regards to the open records, and that's not my question.
Right, I understand. I think that I understand that you are frustrated. And I understand that you want to explain yourself, right? And that's fair. You're entitled to do that as a witness. But I think it bears reminding that when she asks you a yes or no question, to the extent that you're able to answer with a yes or no, you can then explain if you choose to. But it will, I think, help move things along and maybe get rid of some of the ongoing back and forth of questions. If you feel like you understand the question and are comfortable answering yes or no, if it is a yes or no question.
Understood, Your Honor.
Thank you. Go ahead.
Thank you. Have you ever talked with Ms. Willis about forfeiture documents in regards to this lawsuit?
The answer is no.
Thank you. Have you ever talked with Ms. Willis in regards to this lawsuit about confidentiality agreements?
The answer is yes.
When?
I cannot recently.
Have you ever talked with Ms. Willis about confidentiality agreements in response to my open records request? I'm not asking for your interpretation of the open records request. I'm asking if you communicated with Ms. Willis about confidentiality agreements in response to my open records request.
The answer is no.
Personnel records. Did you speak with Ms. Willis in response to this lawsuit about personnel records?
The answer. Please clarify, because you did not ask for personnel records. So if you want to talk about this lawsuit, you cannot then say personnel records. That is not clear. Please clarify.
So I'm asking a broad question. Okay. So I'm asking if you talked about personnel records, any. If you say yes, then I'm going to follow up and ask you which records, and you'll have an opportunity to explain that. So I'm going to ask again. Did you talk with Ms. Willis about personnel records? Broad personnel records. I'm not asking you now which records. I'm asking you if you talk about personnel records.
In my capacity as Deputy of Operations, Human Resources is under my scope and responsibility. So yes, if you are being broad, I talked to District Attorney Fonnie T. Willis about personnel records.
In response to this lawsuit?
The answer is no.
No.
So
Okay. So in response to this, just so I'm clear, because that was a little confusing to me, and I apologize if it's my fault. In response to this lawsuit, your answer is that you did not discuss personnel records, the broad category of personnel records, with Ms. Willis. Is that correct? Do I have that right?
in response to your open records request.
I didn't ask that. I said in response to my lawsuit.
The answer is no.
In response to my open records request, did you speak with Ms. Willis about personnel records in response to my open records request?
The answer is no.
Thank you. The documents, you certified documents on August 30th. You supplied them to, I believe, the county attorney and then to us. Did you discuss the production of those documents with Ms. Willis?
The answer is no.
And are ORA requests ever elevated to Ms. Willis?
The answer is no.
So you're the top of the line on ORA.
I'm the business record custodian of the office, Fulton County District Attorney, appointed by District Attorney Fonnie T. Willis.
Okay, so they never have to be elevated above you.
As of anything that came into my division from 2021 to present, no, that nothing has been elevated to District Attorney Fonnie T. Willis.
And just to be clear, you do not know who compiled the 44 pages of documents that we discussed yesterday, those 44 pages that were produced to us in open records in January from your office. you don't know who actually compiled those, correct?
I cannot specifically put a name on who compiled those documents.
But you agreed with me that some of the information is missing from those 44.
I did not agree with you. Let's clarify that, please.
You agreed with me that the to and from lines, I'll be very specific then.
Okay.
You agreed with me that the to and from lines on some of those emails is missing from those 44 pages.
You pointed to me a document. You pointed to me a document and you said, hey, could it? And I said, possibly. So I do not recall saying I agreed that the to and from lines are missing. I did recognize that there was a compilation. I think that's the word that we decided to use, was given to you on January 18th.
Can I go back for a moment? Ms. Merchant,
Mhm.
the 44 pages that you're talking about, do they correspond with Merchant 0055?
Yes, they do.
Okay, my notes indicate that, at least I thought, and I could have written it down wrong, that Mr. Bond testified that he believed Erica Willingham compiled those documents.
You believe Erica Willingham compiled this. And that's, I wasn't clear, my notes weren't clear, and so I'm trying to get that clear.
Okay.
So you believe that Erica Willingham compiled this?
So yes, Erica Willingham is my designated employee. So yes.
So, because and I thank you, Judge, because yesterday I had notes that said you didn't know, and then I had notes that Erica Willingham did. So I just want to make sure we're perfectly clear. Do you know that Erica Willingham compiled those, or do you just believe she did?
I believe she did.
Okay. So you don't 100% know. You're not sure of that.
So I'm 100% sure that she received the request. She handled the request. She submitted the open records request. As I stated yesterday, that particular request was not elevated to me. It is common practice for Erica Willingham or someone from my staff to seek what they believe to be responsive records. It is common practice for them to ask staff, are these responsive records? It is common practice for them to put together records in a document and send it over to the requester. So to be very clear, can I say with 100% certainty that it was Erica Willingham? The answer is no. Do I think it is because she is my 9 to 5 exclusive open records guru? Believe? The answer is yes. Could it have possibly been somebody else on my staff that is designated to open records? The answer is yes.
Have you ever discussed with Erica Willingham about how she compiled those documents, if she did?
Those documents or our general practice? Two different questions. Please clarify.
I'm asking if you ever discussed with Willingham how she compiled those 44-page documents.
Those 44, no, I did not discuss with Ms. Willingham how she compiled those specific documents. What I did do, Your Honor, if I can explain, is have general practices on how to compile documents. So, but I cannot speak specifically to those 44. As I said yesterday, if I may, that those wasn't elevated to me.
Would the ORA, would the act actually allow Willingham or someone else to create a compilation of documents?
Objection,
Your Honor.
Sorry, objection, Your Honor. As the form of the question, would the act require Ms. Willingham to compile the documents?
Would it allow?
I mean, I feel like it might serve your purpose to, in response to her objection, to maybe rephrase it, because it does call for a legal conclusion, which maybe he's qualified to give, maybe not, but.
Well, as the records custodian, is it your belief that the act permits your office to compile documents?
As the records custodian, as someone who has served as a records custodian for a jurisdiction, I'm aware that the Open Records Act does not require staff to compile documents. So the form of your question is inartful.
But it allows, it doesn't require, but it permits. Is that your testimony?
So no, that if the reading of the statute says that we, as the government document holder, is not required to compile documents. So the inverse of your question is inartful. Okay. So can we do it? The answer is, if I want to compile it, I can. Does the Open Records Act require me or mandate I do it? The answer is very clear. I am not mandated to compile or do anything. Have I, or is it reasonable for when I get an open records request to call in an employee? Hey, can I get emails? Can I get emails? Can I get emails? Compile them in one document, send it to you? The answer is yes. And the Open Records Act says yes, because I went over and beyond what the Open Records Act requires. Am I mandated, if I understand your correction, to do it? The answer is no. Can I? Yes. So this is our law school 101. May, shall, must. So I'm gonna need you to clarify if I did not answer your question.
Does the Open Records Act require that you produce the original documents if you have?
If those original documents are responsive to your request,
Yes.
I am required under the Open Records Act to respond to the Open Records Act. So
Does the act require you produce the original documents?
the answer is yes, assuming that the documents you seek are responsive.
So
But let me clarify, as it relates to original, I do not believe that the Open Records Act require original documents. So the answer is no. You're wording the question in an inartful way. So in my world, forgive me, and I'm gonna take my business records custodian hat off, put on my attorney hat. Bad questions lead to bad answers.
I'm going to break the questions down a little more then. So I just want to make sure that we're clear what your answers are. The Open Records Act requires that you, not the original first document. I haven't answered the question.
I didn't say anything.
The original document. If you have an email, okay, and this is the original email, and I ask for this email, the Open Records Act requires that you copy this email and give it to me if it's responsive to my request, correct?
Objection, Your Honor. Again, the question calls for a legal conclusion, and I don't believe as to the form of the question, sorry. I don't believe as to the form of the question, the witness is in a position to answer that.
Okay. Ms. Merchant?
Judge, he is here as the records custodian, and I'm asking if he's testified that he can give us compilations. That's what we're here about. That's the whole point of this issue. And he's the records custodian. He's the person that should be answering these questions.
Your Honor, this lawsuit is not a Q&A on all that you know about the Open Records Act. So respectfully, I understand counsel's question, but if we can focus on the actual open records request, and if his knowledge is limited to what his knowledge is, I don't believe that this is the platform to test his knowledge on the Open Records Act.
Well, I understand your concern, Ms. Monroe, and if she were asking a general question about his general understanding of the open records generally, it's a lot, and so I might agree with you. But there is a specific issue in this case about whether a document that was produced was some sort of compilation. And because that issue is directly relevant, Mr. Bond's understanding of whether and to what extent that can be done, I think is relevant. And so I'm going to overrule your objection and let him answer the question.
Just for clarification on the record. So we need clarification as to whether or not there was a compilation or whether or not there was an original provision of the compilation. Because her question is as it pertains to original documents, whether or not that requires an original document. She's not questioning the compilation. That we're past that line of questioning.
So I mean, I understand the line of questioning that Ms. Merchant is pursuing to be, I understand y'all disagree about this factual matter, but her assertion has been that that 44-page document includes things that appear to have been not somebody found an email and printed it and gave it to you, but someone, screenshotted or compiled the document in some way. And so her inquiry with Mr. Bond about whether, if in fact that happened, that's allowed, is what I'm allowing her to question him about. I understand that there's an ongoing dispute about whether that happened, but her argument factually that it did allows her to inquire if he understands if that's proper, because she thinks she can prove that in fact it did happen. I have no opinion about that because I haven't seen the facts on it yet.
Yes, and I agree with that line of questioning, but as she formed her question here, it was as it pertains to the Open Records Act and what it permits as it pertains to original documents. She's asking a very specific question about the Open Records Act, which leads to a legal conclusion, not a factual conclusion.
But he is not only a lawyer, but also the person in charge of complying with the Open Records Act for the DA's office. I don't think that it's unfair to ask him for his legal understanding of the law that he's tasked with complying with.
Okay.
And that's what I'm allowing her to do.
And Judge,
And again, to be clear, only on the issues where it's specifically relevant about whether he did or did not comply, not broad-based, what is your understanding of open records, et cetera.
yes, and Judge, I'm trying to be specific, and one of the issues is substantial compliance. If they substantially complied, if they tried to comply, and that's why I'm asking why I think it's relevant. Let's, you've probably forgotten the question at this
I
point.
did.
Okay, I'm gonna use the actual emails then from yesterday. Sierra, are you logged on?
I'm sure.
Okay, can you pull up merchant 0055 for us?
Oh, I can look brave.
Okay, so this document, if you look at 0055,
Yes,
just take a look at this because I'm gonna ask you to compare it to a different document.
yes,
Okay, above the Fonnie Willis critical mention search, there's no date. Would you agree?
I agree, no date.
There's no to or from.
There's no to or from.
And if you look where it says PR value for last week, there's no date.
PR value from us. Yes, no date. PR value from last week, no date.
So, and there's no to or from, correct?
No to or from.
Okay. And then you see direct link to story. It says at the bottom of the page, redirect link to story, correct?
Yes,
Okay. So these are all these three, and I'm separating them out just for us today. There's the critical mention search, there's the PR value, and then there's direct link to story. Those three documents are all compiled on one page, correct?
it appears that those three, okay. When you say 3 documents, I cannot tell you if these documents, I cannot tell you that, right? But what I can say is those 3 paragraphs that you mentioned are all on one page.
That's what I'm asking.
You looking at those, you said 3 documents.
Well, and we look at the individual documents.
Okay, that's fine, but clarify, be clear.
Well, we talked about that yesterday. So, and we identified the 3 different documents. So we're going to look at those. But this page, you would agree, the section about critical mention search, the section about PR value, and the section about direct link to story, those are all on the same page.
I agree that those 3 items are all on the same page. The answer is yes.
Great. Let's look at merchant 0138, please. Would you agree that the subject and the body of that email is on 0055, the document we were just looking at? The subject line and the body.
Subject line in the body, yes.
Would you also agree that the to and from are not on 0055?
I agree that the to and from is not on 055. I agree. Can I clarify? I am assuming that this particular document that's in front of me was provided in production to the 140, we did 44 versus the 197 pages. Is that correct?
You swore to this document. This is in your business record certificate. I'm just telling you where it is. You asked.
So yes. So my assumption is correct then. And since my assumption is correct, this was done by the IT and this is in native form. So yes, the to and from. The answer is yes.
The date, February 17th, 2021. That is on this document, but not on the 0055, correct?
That is correct.
And the attachment that says attachments, CM value screenshot, Fonnie Willis, JPEG. That attachment is nowhere to be found on 0055, correct?
Correct.
Okay.
May I clarify?
Sure.
But I do not, there's not on 055. But if we're talking about your open records request,
I'm not that, I didn't ask you about that. I asked you to compare the documents.
so if I'm looking at 055, which was produced in response to your open records request, and we said yesterday that your open records request sought 1, 2, 3, 4, 5, that was the big one, right? And if you are saying that the open records request open records request response is the same or should be the same as the documents were produced from the subpoena, I think that that is a false correlation. But the answer to your question, to be clear, no.
No, that attachment does not appear on 0055.
The attachment does not appear on what you received for the open records request.
And to use your term, does the ORA, the Open Records Act, does it require you to produce documents in your term native form?
Does it require me? I think it requires me to produce copies, images, inspection. So I do not think it mandates native form. Native form, especially with electronic communication, I can do that. But if I give you copies of emails, copy of emails are sufficient. In my practice, just last week, I sent over a compilation, we use that word, of 2 emails to opposing counsel. They called me and said, hey, can I have those emails in native form? I then responded and said, okay, talk to them and let them know that in order for me to produce native form, I will have to go to the IT department. I will have to fill out a form. It's going to take some time because in my normal course of business, I don't have those documents. I have copies. This is what I have. So if you want the native form, I have to go to the IT department. They said, okay. I said, give me 2 weeks. Let's follow up. And I gave it to them in native form. So the answer is that clear?
Somewhat.
Okay, good.
So you do not believe you have to provide them in native form?
The Open Records Act says that I have to give you copies and allow you to inspect. So it's not exclusive.
Okay. And when it allows you to give copies, do you believe that it allows you to, and I'm not going to use the word redact, I'm going to use the word remove. And let me just clarify. Redact to me would be blacking out so that you can see it, what was removed. Removed means removing it so nobody knows that it was even there. Okay, just to qualify. Do you believe the Open Records Act permits you to remove items from an original document in the copy you provide?
With the way that it's presented, if you're not talking about redaction, I'm going to have to agree with you. No, you are not to remove.
And this, so would you agree that the to from is removed from 0055?
The to from doesn't appear. The to from doesn't appear. I cannot say it was removed because again, right? You gave me an open records request. We gave it to you as responsive records. And at that moment it was done. So I cannot tell you if it was removed. You are assuming, right? Based on removing, arguably facts that's not in evidence.
Well, I'm just asking you to look at the document.
There's two different things, remove versus doesn't appear. I'm gonna help you out.
Okay, this document right here,
Mhm.
it's your term.
Okay. Does it
The
appear?
native form, the to or from, the date and the attachments, they all appear on the native form, correct?
On the native form, they appear,
Okay.
yes.
And on 0055, the form that I got in open records, they do not appear, correct?
They do not appear
Right.
in this particular form. That's correct.
Let's look at 0139. All right, so I'm sorry, we were just looking at that. Let's look at 0138 for the record. Would you agree that it references an analytics graph attached as a PDF? And then when you go to the 0055, if you can go to that one, that's there. So someone reading this would assume that there's an analytics graph attached somewhere. Is that a fair statement?
I think that's a reasonable statement.
So move forward to the next document, 0139. This one, the subject says PR value for last week and the body of the email. Would you agree that the subject line and the body appear in 0055?
It does appear in the this document before me. Yes.
Would you agree that the to, from, CC, date, and attachments they are here on the native document and they are removed from the 0055 document?
We talked about removed. I cannot
They
tell.
do not appear, I'm sorry. I tried to use your term.
Yes, please.
Do not appear.
It does not appear in the records that you received on the as a response to your open records request.
So you would agree that it does appear on the native document, but it does not appear on the documents I received in open records.
I would agree with that.
Okay. And then 0140, we can look at that. Okay, this document, and I'm only talking about the bottom, I'm not talking about the top part yet. Would you agree that on this native form, the to, from,
and the date appear on the native form?
I agree. I see it. Yes, it appears.
Would you agree that the to, from, and date do not appear on the document that I was provided in open records? 0055.
Yeah, I do. 055 is not in front of me, but I do not believe it appears.
We can put it up.
Got it. It does not appear.
Okay, let's go back to 0140. The part that's blacked out at the top. Did you do that redaction on your business record certificate? Certified documents, sorry.
Did I personally do it?
Yes.
I don't believe so.
Were you involved in the decision to make this redaction?
I'm pretty, if it was redacted, it was done probably under my request.
Let's look at 0055. Do you see where it says it's a constitutional amendment, which means it needs 2/3 of each house of the General Assembly and then a statewide referendum in the fall of 2020? Still a ways to go. Do you see that section?
I do.
Okay. And see where it says direct link to story and then a to from line there. Do you see that?
Yes.
Let's go back to 0140. Does it appear that the redacted section here is what you just read in 0055 about the constitutional amendment?
Based on the size and text, I think that can be a reasonable inference. And if I may?
Yeah.
So look at 055. I let you know that I did not compile, right? And that was sent under my elevation. As it relates to that document, I looked at it and I probably redacted it under my direction.
The one you certified.
Yes.
But you don't remember redacting it. You just said you probably did?
So it was redacted. And if it was redacted, it was redacted under my request. But if you're talking about if I specifically went into Adobe Pro and did all that other stuff, I can't tell you.
I'm just asking who redacted it.
It was done under somebody under my request.
So
Yeah.
you told somebody to redact it.
Yes.
Okay.
Ma-
Can we look at merchant 0056? Sorry, that one may take a minute to pull up. Can you look at where it says we've had major incoming from the press the last several days? It's in the middle. It says, do you need your critical mention login? And then in a different font, it appears, thanks, if you can resend. We've had major incoming press from the last several days.
What? Thanks. If you can. Yes, I see that.
There is no email that correlates to that in your business record certificate, 197 pages. Do you have any idea where that native document exists?
No, I don't. No, I do not.
All right. Nothing else. Thank you, Judge.
Thank you. Ms. Monroe or Mr. Bowen?
Good morning, Mr. Bond. If I may call you Dexter,
I'm sorry.
if I may call you Dexter,
Yes, please, please.
perfect. I'm just gonna have you just state your title again for the record,
My official title is Deputy of Operations.
okay? And just give me a description of what your job title entails.
Oh, I do quite a lot. Oversee human resources, open records, of course, purchasing department, accounting, graphics, IT at one point. So quite a few things. I like to think that I give the gas to my attorney so that I can run. So whatever they need, we're ready to go.
Excellent. Now, in terms of your role as record custodian, can you give us some insight as to what your official duties are there?
Sure. On the day-to-day, I have one designated staff member who deals with open records, bless her heart, from 9 to 5. This is what she does. She gets about 1,000, probably a year, if not more. She receives them.
And you said 1,000 a year, 1,000 a year what?
Oh, good question. 1,000 open records requests, about 50 to 75 a month. That's her sole job. So she receives it. She goes into the portal. She responds. One more often than not, she handles it. There are certain times, and I'm getting to what's my role, she elevated. If we need to discuss exemptions, if we need to discuss various different things, and then I'll step in. So
Mhm. And you testified yesterday that if there are other members of your office that need to be pulled in on certain projects, that's something that you would do. How often does that happen?
it depends very often. You know, as you know, open records requires a lot of retention. So depending on how much documents, redaction, I'm sorry, you go and I say, hey, get someone that's suited in this particular area to conduct the redactions. Media. A lot of media people want videos. So I would have to go to a graphics or someone on that team to actually look at a video and redact various statements. Anything that's specialized, especially as it relates to the case files, we know. If it's open and active, you're not going to get it, but there are some exceptions. So I have to work with the attorney and I allow them to determine what's not, that's privileged. So it's very difficult for me to pinpoint, you know, who is handling what as it relates to open records. But I can say for a staff member, based on my workload, I have one designated staff member.
And as far as this workload of about 50 to 75 open record requests per month, how does your office manage those cases?
Oh, we manage it through the portal. I call it the portal. A portal is electronic communication. Thank goodness for it. Because as soon as the open records come, my designated employee is able to receive it, able to respond, give a tracking number almost immediately. So that helps. It retains our files as it relates to what we've been submitted, and it allows communication between my designated employee and the requester. So it can kind of reduce some emails. So we use the portal to deal with open records.
Okay, and what are your internal processes outside of the portal? Well, let me backtrack. Have you always, so this portal that you're a part of, can you just give me the title of the portal?
GovQA.
GovQA, and who's that portal solicited through?
Fulton County Attorney's Office.
And were you always a part of that portal?
No, not quite. It was unique.
I'm sorry, what was the name of that again?
GovQA, GOV.
Thank you.
space.
I wasn't sure if y'all said Dove, and I was like, that doesn't sound right. GovQA.
Yes, ma'am.
Thank you.
Yes, as you were saying, I think you were describing,
GovQA.
right, so GovQA. So now have you always been part of so who is the GovQA facilitated by?
The Fulton County Attorney's Office.
And are you the only department that utilizes this Fulton County GovQA portal, open records portal?
No, but I want to go ahead and clarify, give you some history. In 2021, GovQA was done exclusively by the Fulton County Attorney's Office, and we was able to participate. So to answer your question, is a whole lot of people was in that division. Somewhere in
Let's
the
backtrack. I'm sorry, I'm trying to track what you're talking about. You're giving me history about Fulton County GovQA, the portal, or as it relates to your office?
Yes.
Okay, so I think my original question to you was, have you always been a part of that portal?
Not that portal. That's what I was trying to give you history.
Okay.
So we started with GovQA, and it was County Attorney's portal. We left. We had our own portal.
When was that?
2021 to maybe 2023.
And was that when DA Willis started office?
A few months after. So the answer is yes.
Okay.
So we had our own portal.
Okay.
After we had our own portal, we went back into the Fulton County Attorney's Office portal to have somewhat of let's just take a big pizza. We had a pizza slice that's designated for our office. So it was very difficult to say it was yours, then it was mine. We had two, then we came back in. So it was a big one, but I have a slice of your one.
And how many, so this portal, is it solely for the DA's office use?
No.
Okay.
So my slice is, but the portal as it is right now has I would assume every department in Fulton County.
Okay. And is the DA's office deemed a department of Fulton County?
Yes, we're an agency of it, yeah.
You're an agency of Fulton County?
The Office of Fulton County District Attorney is a state agency.
Mhm. So is it considered a local Fulton County
No.
agency? Okay.
No,
Um,
but
and-
no.
okay. And as far as the records that are maintained on this portal, is it your testimony today that Fulton County, by way of use of this portal, has custody of those records? Of your records, I'm sorry, that are contained by your office, the DA's office?
It's in the portal, but I don't know if they have the custody. Those are my records.
So outside of the records being maintained on the portal, let's say if the documents are never uploaded on the portal, would Fulton County have access to
No.
the records of the district attorney's office?
Thank you for that. The answer is no.
Okay. Now, if, for example, Fulton County would need to access some records on behalf of the DA's office, how would they go about doing that?
If it's Fulton County, they will probably contact me as the business record custodian.
And then what?
Depending on what they ask, it goes in various different routes.
But ultimately, if there are documents to be provided, who would provide those records?
It would be me. It's my responsibility.
And when you say me, do you mean you in your official capacity as custodian of records?
Yes, me on my team.
And okay, thank you for that background. So in maintaining these requests, you mentioned that the portal has been very useful in
Yes.
maintaining those requests. Any other operations within your office that take place to maintain those records or to maintain those requests? What are some of the things that occur within your office internally to manage these requests?
It depends on what the request is, right? I look at it in several boxes. If you are asking for documents that fall in a box of, we know it's coming, right? Let's think about in January or something. I know that I'm going to have an influx of a request for a specific document. We try to go ahead and compile those documents. So soon as when a request comes, we can get it out, right? So that's a way of, if we know it's coming, we anticipate it's coming. I know you're going to ask for this particular contract, this MOU. I have it ready to go. We're ready to go.
Okay, perfect. How about meetings? Do you guys hold meetings?
We do. My open records, I have a staff meeting on Tuesday. My staff meeting on Tuesday is with a whole host of people. The reason why I bring that up as it relates to open records is because sometimes my 24-hour designee, as I call her, she works around the clock. She has a request, and let's say it's asking for something that I don't know. That is her opportunity to talk about all my direct reports, right? So it may be something that I don't know, but if my lobbyist does know it, or if my graphics designer know it, or if my accountant is familiar with it, is discussed at that meeting, and we can go about seeing how we can get those records, right? Also, specifically for open records, it's important that I have a one-on-one, if necessary, on Thursdays. You know that I got a tight deadline as it relates to open records, so that Tuesday, Thursday works, right? So if I hit it on Tuesday, then I can touch it on Thursday. At some point, I can try my best. Of course, with 1,000, we're not perfect, to hit a turnaround or have a valid projection of when I'm gonna be able to get it.
Is DA Fonnie Willis ever part of those meetings?
No,
How about any member of the Fulton County Open Records team? Are they ever a part of those meetings?
no.
Why not?
Oh, those are my staff meetings. Those are all my direct reports, people who report directly to me, my executive assistant, my HR, my accounting, my whole operations division. We sit around, we powwow, see what's going on with the office, and then we strategize for each respective division. So they wouldn't have a reason to be there on the team that I lead.
Does Fulton County Open Records team ever have anything to do with your?
Oh, no.
Sorry, let me just finish the question. The open records requests are received by the DA's office?
Sometimes I'll reach out for help if I don't understand anything, but to that extent, no.
Okay, talk to me about that. When you say reach out for help, how is the Fulton County Open Records team of assistance to your office?
They have more resources, to be honest with you. So if it's a redaction project, perhaps I'll say, hey, can you help me out here? If it's a legal question as it relates to an exemption or of interpretation, I would jump on a call and say, hey, let's powwow. What's your take on this? So it's another set of bright minds that I can discuss things with.
So it's more like a consulting type of relationship.
Absolutely.
Have they ever provided records? Has a Fulton County Open Records team ever provided records for requests that have been submitted to your office? Have they ever provided or produced documents on the district attorney's office behalf?
No.
You testified about the cyber attack that took place in January of this year. Do you remember the exact date?
I don't. I remember it was at the end of January. January was a crazy month. So.
Mm-hmm. And how did that cyber attack affect the operations of Open Records in your office, in the DA's office?
We couldn't have access to the portal. You know, electronic communications was down for a quick while. So what we did do is actually consult with the county attorney's office. I remember receiving a template of a letter saying, hey, we need to put requesters on notice saying that things was going to be significantly delayed. There was a period of GovQA. I don't see it every day, that we just really couldn't get files, or we couldn't access files GovQA in itself. It also infected our office because, you know, a lot of our requests require us to go to archives, go to emails, do electronic searches, right? At one point, there were things best way to put it, our hands were strapped during that period. And we wanted to communicate that effectively to all my requesters.
Mm-hmm. And so would you say that as a result of the cyber attack, has your department fully recovered?
I'm going to say no. Again,
They've recovered from a cyber attack?
Yeah, I'm going to give her a little bit of latitude to the extent that I'm assuming she's going to argue affected his ability to comply. Go ahead.
oh, well, with that being said, I'm going to say no. We could not recover for a couple of different reasons. The cyber attack was put some stress on my staff from January. But as a personal note, as a business record custodian, I'm not sure if you know, I had surgery in December. So I was out of work quite some time. I broke my toe in October. After I broke my toe in October, had surgery, a procedure in November, had to have surgery in December, was out of the office for quite some time, had limited work from January to February. So then a cyber attack happened. So if we're talking about personally my ability, let's talk personally first and then a cyber attack. So coupled with those things and my working level and resources, things was difficult for this particular year. We started 2024 off very interestingly.
Mm-hmm. Do you have any, would you say that increased the cyber attack caused an increase in lawsuits as it pertains to any open record violations?
I don't think it increased in lawsuits because I am prideful of the work that my staff do on open records. I don't, giving my designated staff and how many records requests that I received, open records lawsuit isn't something that typically we get, right? So I'm proud of the work. So I would not say that the cyber attack contributed to that. I will say that January was an interesting month for the Fulton County District Attorney's Office and the influx of open records requests from January because of a high profile matter that the requester is familiar with. And in giving the dates of that particular high profile matter and the dates of those requests from the requester and so many other resources. January was February, March, April.
I understand.
Was crazy.
I understand. So I'm going to shift gears a bit. Thank you for that background. Are you familiar with the requester in this case?
Mrs. Ashley Merchant?
Correct.
I am familiar with her.
And how are you familiar with the requester?
First, by way of this lawsuit. Secondly, Ashley Merchant has subpoenaed me a few times on various different matters. Ashley Merchant has used my name in public forums in various different forms in a manner which in my opinion lacks candor. So I do not have a personal relationship with Ashley Merchant, but she seems to often use my name in things.
And I'm sorry if I wasn't specific, just more on a professional level as it pertains to open records requests. How have you come to know the requester?
Well, hang on. Y'all, I heard lots of stuff from Mr. Bond yesterday that Ms. Merchant makes lots of requests and that he's very familiar with her. I think we've made that point.
Okay. Okay, so as it pertains to the critical mention records that were submitted back in January, the 44 pages of emails. Want to bring you back to that period. I know we testified at length to that yesterday and today. I just wanted to clarify, in preparing, I do want to give you a fair opportunity to explain to the court today what your process was from the receipt of that request to down to the production of that request. Can you walk me through that, please?
Yes. So January 8th came. The request, if I recall, came into our open records team. Our open records team did a response. We supplied those documents. As it relates to my involvement to that particular open records request, critical mention, I cannot tell you that I had any involvement. What I can say specifically is when there are emails or requests, I do it in two ways. The first, as it relates to email requests, is my staff has complete authority to say, if you're looking for emails related to Dexter Bond's birthday party, and you know that someone knows Dexter Bond's birthday party, reach out to them and let's figure out how we can, compile emails, understanding that my staff, if you know my staff and you know about Dexter's Bond birthday party, let's get those emails and let's get it over to the responsive document. So that's one way. Reach out to the people. If you got copies, I can forward emails. I've done that. I've copied emails. I have done that. And so the second thing is, in the event that you ask for emails from a specific date range, my staff only has limited range. I think my emails go back to a year. I can then go to the IT department. IT department can give me emails, but I have to fill out, I call it a matrix, a ticket, an Excel sheet. So I have to provide them several different information. It takes some time, and they have the capacity to go from a long period of time, right? To get various different emails. Those emails are given in the form, and then I can go ahead and forward them all. So to answer your question, as it relates to that critical mention, the first one, I had nothing, I did not do anything, but my team could have reached out, could have compiled documents. I will also say
When you
that
say could have, did they or could have they? Which one was it?
they did
Okay.
call, do whatever they need to compile a document to provide responsive records. In my experience, if someone did not like the copies or the image of the emails that was provided, then they would have called me or called my staff and say, hey, I see this particular email. May I have it in native form? I have done that. And then I will go ahead and let them know, hey, it's going to take some time. Got to go over IT. Here's the copy as it relates to the native form. And then I can provide them it that way too.
And did the requester in this case send you any communication following up regarding the form of the emails or the contents of the emails, questioning its native form?
No, they did say that open records request, as I testified, had several different parts. They did reference it and acknowledge receipt. And they did say that this is one part that's missing. So to answer your question.
What was that one part that was missing?
The graphs, analytical graphs therein in critical mention.
Which were located where in the emails?
I'm sorry?
Graphs as it pertains, which were located where in the emails?
So in the emails, it was mention of critical mention and then said reference graphs. The second open records request said, I want the graphs that was in the responsive documents. Give me the graphs.
The graphs that were in the attachments?
The graphs that was in the responsive documents that I gave.
Okay. And so how did you address that follow-up from the requester?
At that time, I responded and said, I do not know. It's not reasonably calculated to know what you're talking about. Because at that time, I had no idea what she was talking about.
And what were your attempts to research the graphs or the attachments that she was referring to?
At that point, I start staff meeting. Hey, I have something, critical mention. What is critical mention? What is that? Are there any graphs? Then I start reaching out to various different people. Originally, I thought it was security because critical mention, I thought it was some research device. Then I thought maybe it was, let me see, some investigative tool. I did later finally realize that it was a media tool. And at that moment, start saying, educate me. What is it?
Mm-hmm. And who did you consult to educate you?
That was a Jeff DeSantis. Once I figured that out, that was a Pallavi Bailey. Hey, what is this? And then at that moment, we realized that you wanted some graphs that was embedded in the actual critical mention.
Uh-huh. And so once you were educated on what critical mention was and what exactly they were asking for, what were your steps then to see if that information was available?
So that was, let's make a call to critical mention. Do we have, first and foremost, do we have critical mention, right? Because in January, when I got the open records request, I didn't have critical mention. So it wasn't something that I can log into. Hey, Jeff, do you have a portal? Do you have a username? Let's go in. Can you get it? Oh, we don't even have critical mention anymore. Hey, critical mention. Is it a way that I can get this? You don't have an account with us. So those are my steps. I did not have the graphs. I did not have anything that was embedded in critical mention because I don't have critical mention.
Mm-hmm. And so you called critical mention.
Me or my staff, somebody called critical mention. That was an assignment.
Do you know who called critical mention?
I don't know who.
And you consulted with your staff?
Oh, I definitely could talk to my staff.
And were they able to provide you any additional information about these attachments?
No, not at that time.
Okay, and given that this information were a part of these emails that were from members of your office, such as Jeff DeSantis, Jerry Murray, Fonnie Willis, Ms. Pallavi, did you reach out to them to have them search their respective emails to get that information?
Yes, I did.
And what if anything came up from that?
I remember talking specifically to Jeff because he was our point. Hey, do you have critical mention? Jeff did a research, gave me some emails. At that time, if I recall correctly, the graph that was being sought was dated from maybe 2021, 2022, whenever we have it. I indicated that my staff have limited access to their emails, right? They can only go back to a certain period. I know I have a good year. Anything outside of a year, I cannot actually get to. So I go through archive.
Mm-hmm. So when would you say you had to sit down with these respective members from your office to search for emails back in 2021? What year were you in?
This year, 2024.
2024. So, right, because the request was in 2024,
That's
correct?
right.
All right. So were they able to find anything in their emails?
No.
Okay. Did they make any attempts to look through their emails?
Yes.
And what were those attempts?
I remember standing over Jeff's shoulders, hey, let's look for these search terms. Do you have it? Do you have these emails? I remember IT works under me, having my IT director go downstairs and look. Do you have it? Let's look again. So those was the things that I did to.
So the IT person who's this IT person that helped you?
IT person that helped me, that I think I assigned last name Stokes to that matter.
Mm-hmm. And just give me some description, a little bit more detail as to how, what his attempts were in combination with you and Mr. DeSantis to get those attachments.
So purpose of the staff meeting, so many different interchanging parts, right? I say, hey, I need my IT department to go help Jeff, right? Simply because Jeff not an IT guy. Let's make sure, let's look in these emails, let's use these search terms. How far can we go? What have we done? And he was able to say, I cannot find anything. And actually it was him who confirmed that it goes back to a certain date.
Okay. At any point, did your office or your team, your open records team, consult with the Fulton County IT team to get access to these records?
Yes, eventually.
Okay, and how did you how did you do so?
As a response to the subpoena, the subpoena was very specific. It was emails to A from B with search term A1, B1. I was able to use that particular subpoena, put it in a ticket, allow IT to go over all various different emails. IT, Fulton County Department, not to be confused with my IT department, has the capacity to go over so many more emails, and they was able to retrieve items in their native form.
And when we're going to get to the subpoenas, but before then, when after the action back in January, when the open records request was submitted and you received the follow-up from the requester regarding the attachments, and after speaking with your team and not being able to get to those emails, did you contact Fulton County IT regarding those attachments?
I contacted, I got that in January, and I remember saying, I don't know what you're talking about. I remember having conversations. My first contact with IT probably came in February. That was when I returned, and it was more specific, not about the attachments. It's more about, do we have a contract? Like, I was looking for various different things. Like, what is critical? I was ignorant at this time. What is that? So that was my first point of contact. February was a crazy month. About March, we start having conversations about, is it a way that I can go retrieve? What can I do? And then very soon thereafter, I think I received a lawsuit.
Mm-hmm. Okay. Have you ever encountered this issue where your team has requested emails and were not able to access attachments in those emails?
Yes, it happens often.
Okay. And how does your office address that?
So the first thing is, if I want to know specifically what the requester is looking for, right? So rule number one is, let's pick up the phone and let's try to communicate. What's going on? What are you looking for? Because I can try to figure out if there's a better way to get it, right? Then two, it's, hey, let's sit down with so and so and let's do. My attorneys are busy. Let's do some research. Then three is, let's go to the IT department. So it's like a 1, 2, 3 step.
Mm-hmm. Okay. Now, just to be clear, did you contact Fulton County IT team, or was it the IT team that you contact within your office?
Both.
Okay. And were they able to help you to get those attachments?
At that time, I do not recall. I did not get those attachments, so I'm gonna say no.
Okay. And so as a result, you provided those pages, those emails that consisted of the 44 pages, correct?
Well, those 44 was prior to me even knowing what critical mention was, but they was provided in response to an open records request.
Okay, and those were your efforts made after being notified by the requester that you were seeking these attachments?
Those is my efforts for the specific request that she raised and saying she was missing. Those were my efforts.
Anything else that she followed up on in terms of what she was missing from the original provision of documents?
That was the only thing.
Okay. Now, so nothing about contracts, payments?
No.
Critical mention?
She did not follow up.
Okay. All right. And now we're at the subpoena stage of this lawsuit. Who compiled those records? Who compiled those records in response to that subpoena?
IT department at my request.
Okay. And how did you submit that request?
I call it a ticket. Some people call it a matrix. Some people call it an Excel sheet.
Mm-hmm. And what did you put on that ticket?
Exactly. Copy and paste it from the subpoena. The from, the search terms, the search items, you can go ahead and put in the ticket. Make sure that you are hitting those hot button issues. What I do know from my conversations with IT, they always tell me garbage in, garbage out. So they're constantly, hey, you did not do this. I recall, as it relates to that subpoena, being very specific because it was these search terms to our employees, right? So that allows IT to really go, they got a limited database to work. If your request is any emails related to critical mention, the garbage in is going to get garbage. You're not going to get as much records because your search term, who are you asking? Who is it from? Is anything specific? So I like to think that the subpoena was specific and IT was able to help me on that.
So your testimony today is because the subpoena was more detailed as opposed to the original request, which is the reason why you got different results or different emails?
I knew exactly what they were seeking for in the subpoena. I knew exactly where to go. I was educated at that time because it was laid out. I went to the right source. They was able to pull I didn't even have to go to my staff at this one. And they was able to pull my files through archives and pull any and all records.
Mhm. Were you surprised by the amount of emails that came back from IT as a result of the subpoena production?
I don't know if I had an emotional reaction at all.
Okay, that's fair. Moving on to the forfeiture request, the request regarding the forfeiture reports. You testified that you provided an equitable share agreement. Were you aware of the forfeiture reports that were shown to you yesterday during yesterday's hearing?
At the time of I received the open records request, no, I was not aware. No, I was not aware.
So is it uncommon for your office to submit documents of that nature outside of your notice or outside of your consent?
Yeah, I would say yes, because some of those was filed, right, with the state. And with the documents that I saw, the first one, my name wasn't on. The second one, my name or my staff wasn't on it in both the first and second one. The third one, it appears that my name was typed, but another email. So to answer your question is, it's not really in my division.
And what I recall from your testimony yesterday is that you were not aware of this document. When did you become aware of this document?
When my counsel presented it to me.
And do you remember a time frame?
Within the last few weeks.
Okay. And so it's safe to say you weren't aware of this document back when it was requested in January?
No, in January, honestly, I did not know what her request is. In my experience, I get, again, of the 1,000 requests, only a certain percentage comes to me. And based on my experience, I can kind of gear if someone really wants a specific document, and I can jump on the phone and say, hey, what are you looking for, right? In my experience, when I have a lot of open records requests is extremely broad, things become a little bit more difficult. This one, in my opinion, was very broad, but I was guided because of my expertise, right? As a county attorney, I filed with the local governing authority. Mm-hmm. And because I knew what that meant, right? I was like, okay, I know who the local governing authority is. My next step was clerk of the Board of Commission. I'm looking for forfeiture documents because, as I recall the request, there wasn't a distinction between state and federal. I'm looking for forfeiture documents. Do I, on behalf of this office, or does this office file forfeiture documents? The answer was yes, the equitable sharing agreement. Mm-hmm. Does it talk about property? The answer is yes. This must be responsive. And this was a case where I went, honestly, in my opinion, over and beyond, because I didn't know what she was talking about. But I was like, oh, wait, this is really in my wheelhouse, right? Let me make a call. Called the governing authority. She said that we filed it by state law. The governing authority gave it to me. And then I indicated, trying to communicate, we believe this is what you're talking about. And I gave it to her free of charge in response to so many other things. So. Mm-hmm.
And you provided that report prior to the filing of the suit, correct?
Yes, January 26th, along with my letter.
And was there any and there was some follow-up communication between the requester and your office stating not this equitable sharing agreement, we're seeking something else. Do you recall that communication?
I don't.
Okay. And if you knew that this strike that. Now, in terms of the request regarding the non-disclosure agreements, you testified that originally, when you received the request, you thought the requests were pertaining to media, and that's the reason why you didn't provide it, because your office didn't possess any NDAs regarding the media, correct?
That's correct.
Now, were you aware of any NDAs at that time of the at the time of the request? Were you aware of any NDAs that would have been responsive to this request?
No NDAs that prevented my staff from talking to the media. I was not aware of anything.
And at what point did you, and was there any follow-up by the requester regarding this response when you indicated that there were no responsive records?
I don't believe not through the portal. And of course, Ashley Merchant and I don't converse via email. So I don't believe so. No.
Mm-hmm. And at what point did you realize that she wasn't, well, yesterday you testified that you came to know about, yesterday you testified that you gained clarity as to the request, that it was not limited to the media, and that it was a request essentially generally addressing confidential agreements. When did you learn that?
During the course of this hearing.
Give me a time frame.
Within the last 2 weeks, I do recall the subpoena being extremely more specific. And if I could recall correctly, she took out any mention of media and only focused on confidentiality agreements. And once that happened, only confidentiality agreements, that's when I start conversing who has confidentiality agreements. Did, in my opinion, my due diligence to provide what I had as quickly as possible.
Was it brought to your attention by someone?
Yes.
Who was it brought to your attention?
My counsel.
Okay. And after learning that this request was encompassing not only NDAs for addressing the media, but that it was addressing all NDAs, what did you do at that point?
At that moment, I acted as I would with any other open records request. What is it? Who has them? Because this was a situation where my staff, we don't sign them. So well, my direct reports, let's be very clear. Who has them? Where are they? Do they exist? What are they? Just generally confidentiality agreements. And I knew they did. I just had to go figure out where they were.
And after that research, were you able to discover any NDAs?
Well, confidentiality agreements, I don't call them NDAs.
Okay.
Because my confidentiality agreements is, protect my victims' rights. Make sure that what's going on, you don't disclose. We hear a lot of serious stuff, a lot of private stuff. So and I had to go into that particular area, see what was going on.
And so were you able to locate confidentiality agreements?
Yes.
And what did you do at that point upon locating them?
Gave it to my counsel.
To do what?
I'm assuming my counsel gave it to Ashley Merchant.
But you gave it to your counsel to give it over to the requester.
Oh, yes,
Okay.
yes, ma'am.
Now, do you believe that the provision of those disclosure agreement satisfies the request?
Now understanding that it wasn't limited to media, I do believe that responsive records in which I was able to find at that time satisfied the request.
Do you believe that there are any additional confidentiality agreements?
I have no reason not to believe there are.
Is this something that your office is researching ongoingly?
Yes.
Okay, and is it your plan or the plan of your office to provide those documents as they're made available to you?
That's my next Tuesday staff meeting. I got a list of things. That is one. Kind of been busy this week. So if there are some more, this is why I assign things. Hey, can we let's talk about that. Let's see if they exist. Where are they? But I don't know. But I'm pretty sure that on Tuesday, 11:30, I'll be updated on the issue.
Okay, there was some testimony and some questioning regarding possibility of altering any documents that may have been provided to the requester, specifically as it pertains to critical mention documents. Is it your testimony at all that these documents, that you have any reason to believe or any suspicion to believe that these documents have been altered, the critical mention emails?
No, not the substance of the emails. I do not have any reason to believe that the substance of the emails has been altered.
And so even after the illustration that took place a few moments ago, where you noticed that there was a to and from missing, the dates that were missing, and even the subject line was missing, do you still hold that position?
I do. I don't think any substance have been dismissed.
And why do you feel that?
First and foremost, I trust my staff, right? I think my staff is well trained. I'm thinking about the person who's designated as my paralegal for this particular matter. She's a trustworthy person. That's number one. Let me start with my staff. Number two, it is completely common for my staff to reach out and try to take particular emails and say, hey, given January, given what was going on, are these responsive, right? So it's completely common that I give you those documents. It has happened, and it will continue to happen, that a requester receives documents and they say, hey, I'm looking at this document. Can I have it in native form? It happened to me last week. And then at that moment, you assign and say, hey, I need this particular portion in native form. It's my experience when someone is really looking for something specific, they're on a search for something specific. So if it's no moving target, I have an opportunity to sit down, communicate with you to figure out what you're doing. The problem is, I like to get you records as quickly as possible for open records purposes. When I engaged in native form, that's not me, right? I'm getting emails from various different staff. When I go into native form, I'm going beyond my direct team, beyond my office to Fulton County IT, and I'm submitting a ticket that falls in line with every other ticket that they're doing. So I typically, to let them know, I'm giving you a copy of this. If you need native form, it's going to take some time. And a lot of times it takes some time. Right now, I'm in a discovery matter, gave them a copy. It's sufficient, but I have to give them a native form. I think we might be 6 weeks. It's a long time. Forgive me, I don't know a time frame, but it's a long time to get those forms.
And is it a practice of your office to modify or redact, oh, no, I'm sorry, not redact, but modify or manipulate documents outside of redaction? Is it a practice of your office to do that with documents that are produced by way of
Absolutely not.
open records? requests?
Absolutely not.
Okay. And has there ever been a situation where your office has ever been accused of doing anything of that nature?
Absolutely not. Not under my leadership. Absolutely not.
And what is your position or the understanding of your open records staff as it pertains to manipulating documents? Do you have a policy in place as it pertains to that?
The policy, I think that we talked about, all records should be maintained in accordance with the Open Records Act. That's specific. General, we take an oath to the highest esteem, right? So with any allegations of anything that violates that oath or violates the law is seriously taken under the leadership of Madam DA Fonnie T. Willis, and as the board of, and in my capacity as deputy of operations, that won't be tolerated.
Okay. Were any of the documents that were produced to the requester manipulated or revised in any way?
No.
Were any of the documents provided to the requester redacted in any way?
Yes, she showed me one that was redacted.
And as it pertains to your production of documents as a result of the subpoena, who handled the redactions in that production?
I can't tell you specifically who.
Okay. And what is the policy or practice within your office as it pertains to redactions?
It depends.
Mm-hmm.
So a lot of times it depends on what I'm redacting. It depends on what the exception is. If I'm doing attorney-client privilege, right? If I'm returning confidential work product, if I'm doing privileged information, social security numbers, depending on the level of it, determines how I'll assign. If you know, so there's levels to it.
Mm-hmm. Okay. We are moving on to the list of the requests regarding the list of hirees and their date of employment. You testified yesterday that your office does not maintain such lists. Is that still your testimony today?
That's still my testimony today.
How do you play, so who's responsible for payroll in your office?
Ultimately, me.
Okay. And how are you able to, or do you use a list to to process payroll in your office?
A list, no.
And would Fulton County have a list of employees and their hiring dates?
So my conversation with the Human Resources Department said that Fulton County will have a date. They should have a hire. It's not necessarily a hiring date. It is a date in which they move to various different specs, so special in class. So they did say they have that, but it's not reserved for attorneys. It's for all employees related to Department 480. So it's almost like a pay registry for a class. So they do not have that.
So is your answer yes or no that they have that list?
No, they don't have that list.
Okay. Was Deputy Shalonda Miller ever involved in the requests that were submitted to your office or subject to this lawsuit?
No,
Do you recall that letter that was shown to you yesterday that had Shalonda Miller as the custodian of records on a letterhead? Do you recall that letter?
yes,
And the requester has alleged because she received that letter that she was involved, Shalonda Miller somehow was involved in the processing of this request. Is that your testimony today?
I'm not sure I understand the question.
So as a result of this letter being received by the requester with this letterhead showing Deputy Shalonda Miller on the letterhead, there's a position that has been taken by the requester that Deputy Shalonda Miller had some level of involvement as it pertains to the request subject in this case. Do you believe that to be true?
That is not true. And if I can explain, during the cyber attack, our job as my particular, Deputy Miller is on the Fulton County side. I'm on the DA side. This is an opportunity for me to consult with the county attorney and say, how are you handling cyber attack? Because my one person over here cannot get to the system. Deputy attorney or the county attorney, I can't tell you who, said, hey, here's a letter that we can update our requesters. I took that particular letter. I remember being at a particular staff meeting and saying, hey, let's use this letter and let's update everybody, not just specific to this requester, but let's update everyone as it relates to the cyber attack because we expect significant delays.
Okay. So it's your testimony that that letter was provided by the county just to address the cyber attack, and that is all?
Yes.
Did it have anything to do with the actual underlying request per se?
No.
Okay. Moving on to the request regarding rebranding of DA Fonnie Willis. Did your office possess any materials regarding rebranding?
I don't know what rebranding is.
Okay.
So. But I do know that the office does not request. I remember the request being for bidding or something like that. Don't know what rebidding is, but if you're talking about anything related to bidding, the answer is no.
I'm sorry, to what?
Rebranding,
No, you said if you're talking about
bidding.
anything in
bidding.
bidding.
Yes.
Thank you. I just didn't
I'm
quite hear the
sorry.
word. That's
That-
okay.
I am from Washington, D.C. That it goes a little fast. The request, as I understand it, was for bidding or payment bidding, like using various different competitors to see if there was a bidding process for the purchasing of such and such.
Yes, and I'll read the request as it pertains to rebranding. Any payments, requests for payment, process for hiring bids and paying vendors for rebranding material. Did your office at the time of the request possess any of those items?
No,
And what was your response to that request?
we do not possess such items.
And was that response provided to the requester prior to this action?
Yes,
And was there any follow-up by the requester once you provided that response?
not to me, not to my knowledge, no.
As it pertains to the request regarding promotional material, any payments, requests for payments, process for hiring bids and paying vendors for promotional materials, including promotional brochures, flyers, or mailers. Did your office possess or have any control of materials responsive to that request at the time of the request?
I don't, no.
And what was your response to the requester was no responsive documents, correct?
Yes,
Was there any follow-up by the requester after that response?
no.
When did you come to learn that this was an issue in this litigation?
When you brought it to my attention. This-
When was that?
Within the last couple of weeks
And is it your testimony that that was the case for the rebranding materials?
as well, the institutions.
And is that your position as it pertains to the list of hirees and its hiring dates?
Yes, that's my position.
And is that your position as it pertains to the confidentiality agreements?
Yes, that was my position.
No further questions, Your Honor.
Mr. Vaughn, just have a couple follow-up questions. You told, you said that you didn't know how the documents were compiled, the 44 pages, right?
The 44 pages that were
Yes.
submitted to you,
Yes.
January, no.
But then you just told Monroe that you knew they were not altered. If you don't know how they were compiled, how do you know they weren't altered?
I told Monroe our standard practice as it relates to preservation of particular documents. So you're right. I do not know how that was compiled. I had nothing to do with it. But I also referred heavily in my testimony on the trust of my staff and the standard in which this office is held.
So you don't actually have personal knowledge that they were not.
I don't have personal knowledge of anything related to those 44 pages at the time that the request was given.
And you testified for Ms. Monroe that the first time you discussed critical mention was in January of 2024, correct?
The first time that I discussed critical mention?
Yes, you
What
said-
is it?
Yes, you said you didn't know what I was talking about and that you were ignorant. You said I was ignorant to it at the time in January 2024.
As it relates to the analytical graphs, let's be clear.
Okay.
As it relates to the analytical graphs, I did not know what you was talking about, right? I responded to you and said that it is not reasonably calculated to put me in a position to know what you was talking about. So you gave a request. I did not know what was talking about. I told you that I did not know what you was talking about.
And I'm just asking you about what you talked to Ms. Monroe about, okay? So I'm just asking you about that. You told Ms. Monroe that you were ignorant to what critical mention was and that you had you mentioned you had a staff meeting where you weren't sure if it was for investigative or what it was for, and that was in January 2024, correct?
So in January 26, I said I did not know about the analytic graphs. You were clear? As it relates to critical mentions, after that, let's figure out what critical mention is. At a staff meeting that happened January, February, I cannot remember, let's talk about, here's a topic of things. What is this?
Okay, and so that, I'm just trying to lock down that staff meeting where you consulted with staff that you talked to Ms. Monroe about, that happened in January or February of 2024.
I cannot tell you when the date, but I remember I responded to you on January 26th. I believe it was a Thursday or Friday.
And I'm not asking about you responding to me. I'm
Mhm.
asking about when you had the conversation that you were testifying about. You testified to Ms. Monroe that you had a conversation. You said you were ignorant. I didn't know what that I was talking about.
Mhm.
You said that was in January 2024.
And I'm giving you a frame of reference as to
Okay.
why I'm giving you testimony.
All I'm asking is, I'm just trying to confirm that conversation you just told Ms. Monroe about, that happened in January of 2024.
And I'm telling you, I cannot confirm, and I'm telling you why. Can I explain? My frame of reference is January 26th, when I told you, I don't know what you're talking about. I cannot tell you very soon thereafter when I had that conversation with my staff as to what is critical mention. Let's start there. What is critical mention before I get into the analytical grasp? What is this?
You testified that you discussed, I'm going to quote, discussed critical mention for the first time in January 2024. Told Ms. Monroe that, correct?
Yes,
And that you then, in response, you talked to Jeff DeSantis and Paula Bailey, I believe you said.
at some point thereafter, once I figure out what critical mention was,
Mhm.
those are the people that I've had conversations with.
And you said you called critical mention, correct?
I did not say me. Somebody from my staff made contact because I needed to figure out, one, do we have contracts? Do we have it?
Okay, so your staff made contact, not you.
Yes.
Okay.
Someone.
And that was sometime after this, I'm just trying to follow a timeline. You said you discussed it for the first time in January 2024. The next thing you testified to was you talked to DeSantis and Bailey. And then you said that someone contacted critical mention. That was around that same timeline, right?
Somewhere around the same time. I'm giving you the steps. I cannot do linear. Okay. So forgive me.
That's fine. I'm just trying to confirm that that was after my January request.
Oh, yes. After your January request. Oh, hold on, pause. Your January request, I don't know when it came in. It was elevated to me on January 24th. So there's a period in between. So on January 24th, it was elevated to me. I remember responding on January 26th. That's why I'm telling you today. This is my frame of reference. On January 26th, I said, I don't know what's going on. What is this? On January 26th, at that point, I started making conversations to try to figure out or educating myself on what critical mentions is and what graphs you can possibly be referring to.
And after that time period, you said you consulted with staff because you did not know what critical mention was at that point, right?
Yes.
And you had Mr. DeSantis do a search to try and find some emails. You said
Ye-
you were standing over him.
Yes.
And so you remember talking to Mr. DeSantis about that.
Critical mention. Yes.
And then you said you had a meeting, and that was sometimes after that, you had a meeting where you all, you asked if anybody was able to find anything, right?
I don't think I said that.
Meeting to search where you were unable to find anything was in 2024.
That's not what I
That's
said.
not accurate? Okay.
That's not accurate at all.
So when was the meeting that you were talking about?
I always refer to staff meetings. They come
Yes.
every Tuesday, right?
Okay.
So on those staff meetings, it's, hey, can we find out what is this?
Right.
I think I told you that I first started, I thought it was an investigative tool, a security tool.
Mhm.
Once I nail it down to a public relations tool, that's when I start having conversations with a more directed person. So after that, there was no specific meeting. It was more so, hey, can you sit down? Can you search your emails? What's going on?
Okay. And that was after the January 24th date that you're talking about.
Yeah, that was after.
And then you said that you had IT go and look for things. At that point, you elevated it to IT. That was after January 24th.
After January, two ITs, so
Two
we
ITs.
started with Jeff. The first one was pull my IT department.
Okay.
Sit down with Jeff. Let's do some searching. Do you have this? I was able to confirm, no, I do not have this.
And then you said that so this all happened, you were saying January, February, March. In January, though, you were able to provide some emails, some documents. The 44 ones were provided in January, correct?
So again, forgive me, Your Honor. You remember the documents that was provided to you, the 44 pages, I had nothing to do with, right?
Right. I'm just asking that those were provided. I'm just confirming those were provided.
That was right. Yes, you know that.
That's all I'm confirming for the timeline. Okay. And that was, you don't know how they were produced, but you do know that those were produced in January.
I know how they was produced. They was produced to you via the portal for, what do you clarify?
Did you upload them to the portal?
No, I did not.
Okay. Yeah. Yes, correct. Okay. Judge, may I approach?
The witness, sure.
Thank you. Okay, I'm showing you what I marked was exhibit number 2. You can take a look at that for me.
22, wait, what, I'm sorry, 22.
Are you saying it carries Bates page number
Does not.
002? Okay.
It's not one that I anticipated.
Okay. So what is the 22?
Um,
What is it an identifier of? That's what I'm trying to, so I can navigate.
Yes, it's an email that was produced, to another requester in regards.
Okay.
Email produced by the DA's office. I believe it's from the DA's office. It wasn't produced by the county, but produced by the DA's office in regards.
Okay.
I'm looking at,
If you're looking at, plaintiff's number 22, that you've already looked at, correct?
can I, if it's possible,
Back,
perfect,
the court, one of the other there.
got it.
so someone, I'm sorry.
Can you put it up?
Well, it's
Um,
not in evidence yet, so she
Oh,
can't.
sorry, thank
No.
you.
And I'll bring it back. I'm not trying to hide it from you. I did not anticipate going into this. Someone before me requested critical mention documents, correct? In open records.
It appears to be. so.
Objection, we're not going to entertain, I want to know the relevance of.
It's impeachment. He has literally testified for the last hour that the first time he ever knew about critical mention was in January. And he's got emails in September where they're getting critical mention documents and they're talking about where they get them and all of that.
Is it an
Okay.
email
Well,
from-
hang on. The court reporter is not the only one that's going to get annoyed if y'all keep talking over each other, okay? Ms. Merchant, I understand your position, but I'd like for Ms. Monroe to be able to make her objection clearly on the record so I can hear it. Ms. Monroe, what is your objection?
Okay, so this is the first time we're seeing this exhibit. I roughly went over it. I was not aware that this was a document that produced outside of the open records request, the underlying open record request in this action.
Okay, well,
So the
hang on, let me back up
objection
for a
is-
minute. So she hasn't actually offered that document into
Okay.
evidence yet.
Mhm,
She's asking the witness questions.
mhm.
She's given him an opportunity to review the document that she thought, I guess, might refresh his recollection. I don't know.
Mhm.
But so we're not right now objecting to the document itself because it's not in evidence and I don't know what it says or what it's about because it's not in evidence and I've not seen it. It's not even been offered into evidence.
Okay,
So is your objection to the line of questioning that Ms. Merchant is pursuing?
no,
Okay. Then we'll preserve the objection to the document if and when it arises.
I'm not the first person who made an open records request to your office about critical mention documents, correct?
You are not the first person. A lot of people have.
One requested them back in September of 2023, correct?
It appears to be so, yes.
And that request was for critical mention from May of
I
20.
mean, sorry, that document is not in evidence, so you can't read from it into the record. You can ask him questions
Yes.
about his understanding of it.
That request was similar to my request, asking for critical mention documents.
I cannot speak to that open records request as it was not elevated to me.
The request that was made in September 12th, 2023, in regards to open records request, you're saying that was not elevated to you?
It was not elevated to me.
Would you consider an email being forwarded to you, elevating it to you?
That's a possibility that an email to me can elevate the matter, but that particular request
Mhm.
was not elevated to me.
Okay, so we can agree someone requested in September 2023 critical mention documents.
We can agree that critical mention was a hot button issue.
And we can agree that that person asked for reports.
I don't know what that person asked for. It wasn't elevated to me.
Okay, and you're the open records custodian now, correct?
I am the.
Okay.
And I have testified that I'm the records custodian. The answer is yes.
Would seeing the open records request made to your office refresh your memory as to what was requested?
Possibly.
Take a look at that. When you're done, let me know.
I have looked at this.
You have, okay.
Unfortunately.
The requester asked for critical mention reports, correct?
Based
Hang
on,
on, still not in evidence.
Yeah.
If it refreshes his recollection or if you'd like to offer it into evidence, you can, and then we can talk about the document. But you can't get the substance of the document in just by asking questions about it.
Judge, and what I'm trying to ask him is if there was an open records request for reports from critical mention, if this refreshed his memory or not. If it did,
So
And
two
I-
things, and I'm not trying to be overly difficult about it, but one, you didn't actually ask him, does that refresh your recollection? And two, my issue is you're not asking him a general question, which you did a moment ago. You're asking him, I'm reading from the subject line of this email, did you get such a request? And that is the introduction of what's in that document without that document being in evidence. I know it's nitpicky, but
it's okay. Did you review the email attached to this document?
I reviewed the document that you presented to me just now.
All right. And is your email dexter.bond@fultoncountyga.gov?
I answered yes, that's my email, dexter.bond@fultoncountyga.gov.
Okay. And does this contain emails to which you're a party?
It appears that I've been emailed on that thread.
Okay. Judge, I would move to admit plaintiff's exhibit number 2.
Ms. Miller,
22. Sorry, 22.
Your Honor, we're objecting as to the relevance of this document.
okay. I think the relevance Ms. Merchant said a moment ago when we were talking about the document was it went to, she wants to offer it for impeachment purposes. And so
Correct.
I think that's a valid reason to offer the document. And I'm gonna overrule your objection and let it in. Exhibit 2 or 22?
22, I'm sorry, Judge.
Exhibit 22 is admitted.
Thank you. So it's,
Your Honor, quick question. Exhibit 2, is Exhibit 2 the actual open records request or the email thread? What is it has been admitted?
Exhibit 22 is the piece of paper that Ms. Merchant has asked to have admitted into evidence, which I believe, from my record, was identified a moment ago as an email that you were able to identify as being an email. And based on that, it's been authenticated and it has moved past a business records exception. And therefore, the only remaining issue as to its admission was hearsay. And was relevance, and I overruled Ms. Monroe's objection as to relevance. So that document, whatever it is, and y'all are going to educate me about it, a sufficient foundation has been laid for it, and I've admitted it into evidence.
thank you. All right. The requester asked for reports and payments in September 2023, correct?
So in the emails, the answer is no, the first page. In the second form, which is not an email, that I don't, in this, an open records request was made. 2 different things. The email thread on page 1 of this exhibit is an email in which, yes, I have testified to that I am on the email. This second page, which I cannot determine is related to this particular email because it is an open records request that is from an external sender that looks like it's from the portal. I don't know the condition. So I will have to renew my question. Are you asking about an email? Are you asking about an open records portal? Because they're 2 different things as I see it. So it's not one page. I don't know what exhibit 20, what are you referring to? Are you talking?
I'm referring to, they're a collective exhibit.
How do I, based off,
They're admitted into evidence.
go ahead.
Exhibit.
Yes.
They were provided, they were provided by your office in response to an open records request.
Received.
One page, we can agree, one page appears as though it is the portal request where someone, another attorney, filed an open records request, correct?
This appears to be a portal request.
And I'm not trying to yell at you. I'm trying to talk loud enough so
Understood.
to go back there and we can look at the same document. I just want to apologize. I'm trying to raise my voice.
You're
on
fine.
purpose. Okay. So this page is an open records request in September for critical mention.
This second page,
Yes.
yes.
And this page, if we had a very long piece of paper, Erica, and is Erica Willingham the person that you were talking about earlier?
Yes, my 24-hour designate.
That's the person we were talking about, correct?
Yes.
Erica forwarded this on September 12th, 2023, correct?
To whom? Forwarded to whom? What? Look at
So
it.
if you look at, and I really don't want to,
From Erica to Erica.
So yes, follow, let's see. Subject, work order. All right, so the subject of this email, actually, can I just share this for personal to you? Is that possible?
The microphone?
Yeah.
So unfortunately, mine are affixed to the table, so you can't just pick it up.
So the subject, all right, so if we're looking at these documents, the subject says work order and it's got an open records request number, correct?
Yes.
That open records request number correlates to the portal open records request, correct?
From Erica to Erica, the answer is yes.
That's not my question. The work order in the subject.
Yes,
That number correlates to this document.
the answer is yes.
So it's fair to say that this subject matter of this email, this is the email that was forwarded, correct?
If that's an assumption you're willing to make, yes.
Okay. And Erica Willingham
To the Erica Willingham, yes.
forwarded on September 12th, 2023 at 9:39 p.m.
Yes,
to Dexter Bond.
that's what it appears to be, so yes,
The subject is who is Critical Mention Inc., correct?
because we don't know who that is.
Okay.
Erica,
The email says, "Hi Dexter, see open records request. This requester is saying we purchased a service from Critical Mention Inc. They're requesting the invoice and reports." That was forwarded to you on September 12th, correct?
September 12th, 9:39 p.m. We worked late, yes.
I'm sorry, what year?
2023.
Thank you.
Yes,
And then on September 13th, 2023, you, Dexter Bond, forwarded that to a Natalie Zellner, correct?
at 8:17 a.m. first thing, Natalie, please provide, thanks. Yes, Natalie, please provide, whatever this request is, Natalie, please provide. I'm designating it, yes.
Zellner, that's the same person that we talked about yesterday whose email was on one of the forfeiture documents, correct?
Natalie Zellner, Zellner, you can see her email address. So no, her email was not on that forfeiture document.
It's the same person.
I don't know who that person was on that second document.
Okay, so do you know any more than one Natalie Zellner?
No,
Okay, so if Natalie Zellner appeared on a document with your name for forfeiture, and Natalie Zellner appears on your name with your name on a document here, is it safe to assume it's the same Natalie Zellner?
you could say that.
Ms. Berg, forgive me for interrupting, Ms. Bergdorf, is that the document that you're sharing on your screen now? Okay,
Oh, well.
Thank you. Thank you, sorry.
Perfect, that's good, thank you.
Okay. So can you go down to, just a little bit further down? Okay. So you wrote back, thanks, DQB Junior.
Dexter Quentin Bond Jr. Yes, that's my initials. I'm assigning this to Natalie because I don't know who Erica doesn't know who Critical Mention is. I'm assigning it to Natalie. Natalie, please provide.
Great, okay. And then can you forward up a little bit more? All right, and then there's an email on, let's see what the date is. So
Linda?
the same day where Natalie emails and copies you, Jeff DeSantis and Pallavi Bailey. That's the person that you were talking to earlier, right?
Yes, Jeff
Okay.
and Pallavi.
Open records request, who's Critical Mention? Natalie says they received it. Is this the service you use?
Because we don't know what it is. Is
Right.
this the service you use?
Okay, and if you can go up a little bit more. And then it appears as though you sent an email that says, Tashika, I am including you in this email. This may be something that you and I discussed, correct?
That is correct. Tashika is my IT person. I'm assuming that this was brought to my attention at staff meeting. I'm assuming consistent with my, hey, what is this? This is something we should discuss.
And in October, in response to this open records, you provided the same 44 pages to this requester that you provided to me in January, correct?
I don't know, because again, the 44 pages wasn't elevated, neither was this open records request. I'm seeing this open records request for the first time as I sit here today. So I don't know what was provided in October in response to that, your open records request I testified that to, or in October. I don't know. It wasn't elevated to me.
You rely on IT to preserve documents, correct? That's
Not just IT, but yes, IT helps me preserve documents
you have your own internal preservation system?
for HR files, for various different things. Yeah.
You do?
Old school. Keep the HR files in the closet.
Okay. You explained to us that you know how to go to IT if you need to, correct?
Sure do.
Okay.
And this is Tashika, I'm including you in this email as well. This may be something that you and I discussed.
I'm not asking you about this document.
You said IT. That's an example of IT. I'm sorry.
She was it, if you know how to go to IT if you need to.
That's an example of it, that
Yeah.
document.
So you know how to go to IT if you need to.
Tashika, I need you.
And you did elevate my request to IT once you got the subpoena, correct?
Objection, Your Honor. Are we talking about the IT within the district attorney's office, or we're talking about IT from Fulton County? Because they're two separate.
Any
I
IT.
agree. I'd love to know the answer to the question, Ms. Monroe.
When you got my subpoena, that's when you first elevated my request to IT, correct?
When I got your subpoena, that is when I elevated your subpoena request to IT because it had the required information to fill out my matrix. So that's when I did that. Yes.
Before that, you had never elevated any of my requests to IT, correct?
I cannot say that. I don't know. Because
But you
again,
fill out the ticket, right?
it's you. There's certain, you're assuming that I am dealing with 100% of open records. I'm not. So I cannot tell you in the many open records requests that you gave if a ticket was elevated. I cannot tell you. What it appears is that you requested critical mention. It appears that my staff handled this. It in this exhibit that you admitted, it does not say that I am aware of anything in here.
Can you turn that off? I'm not asking you. to
Oh,
talk
okay.
to me.
So as always, I can't answer that question because again, of the totality, a lot of them don't come to me. Only certain things are elevated to me. And here's the thing. You told me that I gave those 44 documents to someone else. That someone else never came to me, right? And said there's a problem. Just like you never came to me and told me there was a problem.
My question was,
Okay.
did you go to IT on any of my requests prior to the subpoena?
Dexter Bond, I don't believe I did, except for the subpoena.
Okay. And there is a record if you did go to IT, correct? There's a ticket.
There's a matrix form that I would have filled out,
Okay.
or someone from my staff would have filled out.
So if you had elevated any of my requests to IT, there would be some evidence of that, correct?
If my staff had enough to fill out that particular matrix, there should be a matrix filled out because that's how IT operates.
And in this case, I mean, you had talked about IT taking a very long time to produce documents. Is that, you mentioned something about that?
IT's practices takes a long time for native forms.
Okay. In this case, though, well, and I'll ask IT that. You testified that rule number one, you said, is pick up the phone, right?
Rule number one is pick up the phone. Let's communicate. What I've learned, if there's bumps and bruises, you need to communicate because that heals bumps and bruises. Because if you don't communicate, you end up in a courthouse.
You didn't do that with my request, though, correct?
I testified yesterday that I will not talk to you personally. I testified to you that I won't talk to you. I emailed you and let you know, do not talk to me. I told you on the record, and I'm going to tell you again, that I find you disingenuous. I find you very misleading, and I do not trust the way that you practice law. You do so in a way that's not filled with integrity. The
Mr.
Open
Bond,
Records Act do not.
Mr. Bond, I understand that you have strong feelings about Ms. Merchant.
Thank you. Sorry.
You've
Your Honor.
communicated them clearly,
Sorry.
but I need you to actually just answer her question, which is, did you communicate with her about, I think your question was, did you, Mr. Bond, communicate with Ashley Merchant about the nature or scope of her requests?
On January 26th, I wrote you a letter.
And my question was just based on your number one rule, pick up the phone, if you did that with me. That's all I asked. Did you do that with me?
No.
Thank you. Yesterday, at the end of the day, you told the court that you had never seen the subpoena from September 13th, from last Friday. You said you'd never seen that. You didn't receive it. Do you remember saying that?
That's exactly what I said, because I didn't.
Okay. Today, when Ms. Monroe was asking you questions, you said that the reason you provided her confidentiality agreements was in response to a subpoena and how I worded a subpoena, correct? I mean, that's what you told her a few minutes ago.
Yes, that's probably what I said. Yes.
Okay. And that's the exact same subpoena that you got on September 13th,
I
correct?
didn't get a subpoena on the 13th. Maybe she got the subpoena on the 13th and she told me, but I didn't get a subpoena on the 13th. On that Friday, I didn't get a subpoena. I wasn't here. So I know I didn't get a subpoena on the 13th. And I know yesterday was the first day that I received the subpoena that you gave me after me asking you 2 times what subpoena you're talking about. And then finally you gave me a subpoena. I also know that subpoena that on your first subpoena, I was listed on Exhibit A. I was not listed on an Exhibit A, and I told the court very, very clearly something's wrong with that subpoena. So any other questions as it relates to that subpoena that I didn't get on September 13th?
Yes.
Keep going.
When was the first time you saw that subpoena?
When you handed it to me.
Yes.
With my name on it, that was the first time I saw that subpoena. You handed it to me right here, and immediately I said, I did not get that subpoena.
So when Ms. Monroe asked you about providing the confidentiality documents, you testified that you did that in response to the language I used in the subpoena, correct?
If that's my testimony, yeah. That's exactly what I said.
Okay. And that subpoena, so those confidentiality agreements I got on Tuesday, right?
Yes.
Okay, and the subpoena, you said you just saw for the first time, yes.
That with my name on it, that subpoena was my first time on Friday. Now, however, my staff received your subpoena on Friday. I forwarded that subpoena to counsel on Friday. Counsel then said, hey, we have another subpoena, which I was not listed on the Exhibit A. So I assumed it had nothing to do with me. And at that moment, I said, hey, this subpoena is different from the second subpoena open records request. And then that's why I said, you need confidentiality agreements. So no, if you're talking about the subpoena with my name on it, dated September 13th, my testimony is that I did not receive it. Let's be very clear, until yesterday. If your question is, did I see the subpoena that was for someone else because it was emailed to me and I gave it to counsel and I was able to talk to counsel? Yes, I did do that. But the subpoena with my name on it that required documents, I did not get until yesterday.
All I'm asking is the subpoena, the September 13th subpoena.
With my name on it or no? Because there are multiple September 13th subpoenas.
I'm happy to.
So, I think I'm sorry, this is not an official objection, but in hearing Ms. Merchant's representation of what I questioned him about, that is not accurate. I did not talk to Mr. Bond as a result of a subpoena.
Hang on.
I can withdraw
That
it.
is an objection. That's she's mischaracterizing his,
Right.
she's mischaracterizing his prior testimony.
Right, but I do know, I realize I missed the timing for that objection, so that's why I'm saying it's not an objection, but it was because I didn't hear, I wasn't able to process what she was saying. I was actually looking back at my notes, and that's not what he testified to. So if the court would allow my objection, albeit untimely, to object to the recharacterization of my testimony, if the court reporter could read back what I asked him, it was not my conversation as it pertains to those confidentiality agreements were not pursuant to a subpoena. It was pursuant to this action and trying to get this action resolved because it was brought to my attention that Mrs. Merchant was needing of these NDAs, and I was trying to get those documents to her.
Okay. That y'all can continue to disagree. I heard the testimony. I heard, I think that everybody is talking at cross purposes, right? I'm going to let you ask your question, Ms. Merchant. Your objection is noted for the record, Ms. Monroe. But I don't know that it changes the outcome of this questioning, except that I would appreciate it if we could get
I'm
clarity.
I'm done. I can withdraw it. It's fine. The subpoena's on the record. Thank you, Judge.
Okay.
No other question.
Okay. I have a couple of questions, and generally my practice when I have a few questions is, in case I mess up all of your brilliant crosses and directs, to give you an opportunity to follow up on any questions that I ask. Couple of things that I was interested in, Mr. Bond, that I don't think I heard, and I apologize to the lawyers if I did, if they asked you. So when you get a request and then it's closed, right? What is the process or decision making that goes into closing a request that's received?
Once we give a request, responsive documents, or we comply with the Open Records Act, my 24-hour guru will upload it. And once she lets the portal know that it's closed, it's closed. However, in the event that something is closed, you have an opportunity via the portal to, continue to converse. So
Okay. Okay, and so, so when you, one of these requests, you had made a point of noting that it was, and I'm not referring to a specific one, but there were a couple that you were like, you asked me for 5 things in this
Yes.
one request, in this, paragraph that was written. What is your process for saying, okay, 1, 2, 3, 4, 5, we have documents for this, documents for this? Like, how do you do that? How do you identify, have I looked for documents that are this item? Have I looked for, tell me a little bit about that
So a
process.
lot of times it's communication.
Mhm.
Okay. Well, hold on. Out of 100 cases,
Right.
a lot of times, probably 75%, I'm looking for a specific thing.
Right.
I'm looking for a specific case. So it's very rare that I get a 1, 2, 3, 4, 5.
Right.
I get a 1, 2, 3, 4, 5 from certain people.
Right.
Um,
And when you say your staff.
My staff.
Also has, but also like Ms. Willingham or someone, she has the ability to pick up, does she have the authority to pick up the phone and call someone who requests and say, is this what
certain
you're asking
people,
for?
But unfortunately, it's certain people she cannot.
No, right.
Okay.
I totally understand. Just like there's certain
Yes.
types of requests that would be elevated and certain types
Yes.
that wouldn't.
But yes, if it's a simple form, hey, I want invoice 102.3.
Uh-huh.
That's one of our purchasing. Give me
Right.
an invoice, give me a number. She knows exactly, hey, you said any and all. This may take some time. Do you want to narrow it down? Let me tell you what I do have access to. So she has complete authority to make contact for specific items.
Okay.
Right. As it relates to things where, hey, I don't know what this particular document is. She has authority to call various different staff members. Do you know what's going on? Who is this? So she has authority to make some calls, but she has authority not to call some other people as well.
Okay. There's been a lot of discussion about IT. I'm still not sure I'm clear on the extent to which there is a Fulton County District Attorney's Office IT and what authority or what's within their organizational control and structure versus Fulton County's IT department. With full disclosure to everybody that, of course, I also have to, ask questions of the Fulton County IT department sometimes to make my email work, for example.
So I like that example, email work. I got 4 people staffed to my IT department. It was 4, reduced staff. If something's wrong with your computer, something's wrong with your phone, something's wrong with any app, you call your IT department. That's internal.
Mhm.
Sometimes they're second layer. Hey, I know who people are strong on technology. In the event that I need my IT department to stand over Jeff DeSantis' shoulder to make sure that he's using the search tools right, I'm going to call my IT department. With the understanding, if you're looking for specific emails, I can do so for maybe a year. I know my email goes back to a year. I have a lot of emails. If you're looking for anything beyond that,
Mhm.
then I'll call the county
Mhm.
IT department. They can go into archives. They can do things in native form. They can do things with, contracts, and they have the capacity to do things on an AML list. They have those things.
Okay. And then what do you do about, let's say you, like, for example, this list that's been requested, right? And I understand your position that there is not such a list that exists that has the names of all the attorneys that work for the DA and their dates of hire. I understand that. To what extent, when you receive, and we can use that as an example, but my question is intended to be
I
broader.
understand.
If you have something that that is partially responsive, like let's say there's a list of everybody, of all the attorneys that work for the DA, but it doesn't have dates of hire on it. How do you determine when you will try to make an incomplete response or something like that?
All right. First, rule number 1, I get on the phone. Hey, I don't have that list. Let me tell you what I do have.
Mhm.
Do you want hire dates? The hire dates aren't necessarily specific. Hey, and then we can have an open dialogue, me or my staff, depending
Okay.
on what it is. What can we do? How can we help you? But again, sometimes it's very clear. Let's say it's a nonprofit or something, they're doing an MOU for a grant. They know exactly what they're looking for. So it's we can walk through.
Right.
However, if it's something that's, I don't know what's going on, and Your Honor, I accept the fact that without communication, things become very difficult,
Mhm.
right? Because my response or my analytical response is reduced to me and my staff,
Mhm.
right? In this particular case, communication has been taken out. In my opinion, Your Honor, Open Records Act doesn't require me to pick up the phone and have a conversation to someone or a constituent. It requires me to look at the four corners of the request and make my best response and then invite a new Open Records Act and respond accordingly.
Okay, I have two more questions and then I'll let you guys follow up if I've messed anything up. One, I've heard some mention of a person by the name of Tashika and you identified her as an IT person. Is she in the Fulton County District Attorney's Office IT or is she county IT?
Funny. Let me explain. So this email that was presented to me, I don't have a date with that, but it appears that once I realized it's PR stuff.
Well, it's
Go ahead.
just to help you with the date. I think it was represented that that was around sometime in September of 23.
September, she was my IT
So
director.
she worked for Fulton County District Attorney's Office.
Yes.
Okay.
However, in December, she now works for the county IT department. So wanted to be very clear on that. So
Okay.
she's a dual person.
Okay. The last question has to do with, there are some responses, where, the response to the Open Records Act was, we don't have any documents responsive to your request. And then I think I understood that, Ms. Monroe asked you, did you have any follow-up from the requester, Ms. Merchant? And you said you did not. So does it happen frequently that when you say, when you respond to an open records request and says no records, that you get a response? And I mean, generally, not from Ms. Merchant, but generally. By you, I mean the open records team.
So in the cases, the answer is, if you specifically looking for a case number, right? I'm not going to hold you to you missed the last digits of your case number, right? Those are cases where I'm going to honestly, hey, that's my last resort. I don't have those records. What are you looking for? If you want an MAU for my subawardee contract, and I know you pick up the phone what are you looking for? Let me see. So in those particular cases, Your Honor, no, it doesn't happen often. But in the cases, given my staffing levels and workload, that's where, in my opinion, we look at the Open Records Act. I have 1,000 requests a year, or more than 1,000, 50 to 75 a month. In January, when these requests came in January, was a hot button issue. I did not have the capacity, right, to say, oh, have a conversation. And if I did have a conversation, I'm not sure if it will yield any fruit in this particular instance. So I honestly, there's not a lot of do not response. I know in January, you want this particular contract, you want this MOU. Like when you want something specific, typically I can work with you to get it because you have a reason as to why you want it. When it's over broad, I have to pick up the phone. If you want a case file or good case, my rule is open and active litigation. Technically, I can say no. But if you're a civil attorney and you need this limited case because let's have a conversation with you, my ADA, to determine if there's something that you can expect. Is there something that you can do to get what you need and not necessarily impact my prosecution? So I don't have I have a few, and I recognize the name of the person that she presented to, that she referenced in her exhibit. Well, there are certain people who I don't know how to help them, but rest assured, my Open Records team, when you're looking for a document, I'm gonna do anything and everything before I say I don't have it. That's not my go-to.
Okay, thank you.
That's not
I
my
appreciate that. Ms. Merchant, it's your witness. Did you have any follow-up?
No, Judge, thank you.
Ms. Monroe?
No, Your Honor.
Okay, Mr. Bond, you may be excused. Thank you. Okay. It is 12:30. But also knowing that we're going to lose Ms. Merchant at some point, I was thinking that we might continue if people need a comfort break as opposed to like a longer lunch break and go ahead and keep moving along with Ms. Miller, if that's okay with everybody.
I may have some good news.
Okay,
Based on his testimony, we don't need to call Ms. Miller or IT. He's answered the questions about that, so I don't think we need to call any other witnesses based on his testimony.
okay, Ms. Monroe?
For this, if we get to damages, we'll need to do that.
I'm sorry, we're conferring. If you could just give us a
Sure.
moment.
Well, I tell you what, why don't we do this? So I was gonna give everybody a comfort break anyway, and it sounds like y'all need an opportunity to consult, right? So it is 12:33. Why don't we take a break until like 12:45, 12:50? And we'll come back and figure out where we're going next, okay?
Okay.
Thank you all.
You're still leaving at 1. right?
That's what it's gonna say.
Yeah, and I don't have a lot.
Learn our.
Yeah.